Welcome to Tennessee Probate Law from A to Z. Today, we're talking about the letter I. Come on in. Hi, I'm Probate Attorney Dan Scott. I help families work through the probate process in a stress-free environment to provide them certainty and closure when they've lost a loved one. Today, we're talking about the letter I, and I spoke in another video about what is an insolvent estate. Okay, so if you didn't catch that video, just check forwards or backwards, most likely to be backwards, and you'll see what is an insolvent estate. Just really quickly, an insolvent estate is an estate where the assets are less than the debt, and so it's insolvent. So what I want to talk with you about today is that when you have an insolvent estate, the administration of it is different than a solvent estate. And here's how. First thing that happens is you got to decide, are you going to continue to proceed in the probate court? In many venues, you can continue to proceed the probate in the probate court, or you can remove the probate to the chancery court. And the reason you might remove it to the chancery court is, speed with which you can get the matter resolved. You get hearings a lot faster. You're going to have a claims valuation process that you're going to have to go through in the chancery court, and you may end up having to have some property sold in the chancery court, because remember, what you're doing is you're having to bring real estate back into the estate. And that's the other thing. When you have an insolvent estate, what happens is, the real estate that would normally pass outside the estate, subject to the claims of creditors, passing outside the estate to the heirs at law or the heirs under a properly probated will, it's going to come back into the estate to pay creditors, okay? And sometimes you have to have that chancery court jurisdiction, that strong arm of the chancellor to make that happen. So the probate process is going to be a little different. Once you get all the claims satisfied and you get the assets liquidated, now you're going to have a bucket with which you're going to pay claims. And so what will happen usually is the personal representative is going to make a proposal of distribution to creditors, and they're going to get paid really likely on a pro rata basis, right? So if there's $1 million in claims and you've got $500,000 of assets after you liquidate them, let's say $600,000, so you can figure that they're, $100,000 in administrative costs, and that may be an exaggeration, but just for talking purposes. So let's say there's $500,000 left. There's net of $500,000. Then your creditors are going to get 50 cents on the dollar. A lot of times in an insolvent estate, that'd be good, right? A lot of times an insolvent estate is where they're going to get less. Now, somebody asked me the other day, well, why do you administer an insolvent estate? Well, one, you have to once you get started. Somebody's got to once it gets started. And you've got these assets out here that you're going to have to deal with one way or the other. And so even though the heirs don't get the benefit, you are going to reduce the outstanding claims of creditors. And then at some point, they're just going to take a wash. They're going to get a haircut on their claims, so to speak. But you'll get all of the assets of the estate administered through this process that goes on, usually in the chancery court. Well, I hope that's helpful to you. Remember that we're on the letter I, talking about Tennessee probate from A to Z. And there's some more I's that we'll talk about. I hope you'll tune in for those. Thanks for watching.